All right. Honorable Justices of the Supreme Court. Hear ye. This court from recess. Now sit.
Please be seated. Good morning. Ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 10:30 docket.
The 10:30 a.m. docket for Thursday, May 18th, 2023 consists of two cases. First case appeal number 126105 in the matter of Mark G. Ayesh, original action and attorney discipline.
Morning, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. I'm present and ready for argument.
My name is Greg Anderson. I'm representing Mark G. Ash. I'm present and ready for argument.
Second case is appeal number 125968 in the matter of Christopher C. Barnes, original action and attorney discipline.
Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. I'm present and ready for argument.
If it may please the court, Attorney Chris Barnes, respondent in the action appearing pro se. Present and ready for argument.
Your Honor, that concludes the docket for the week of May 15th through 18th, 2023.
Thank you, Mr. Shima. Ask the attorneys to please come forward in 126105.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Madam Chief Justice, I would like to request 2 minutes for rebuttal.
Brandon, thank you.
Thank you. This is an original action and attorney discipline involving respondent Mark G. Ash. Mr. Ash was admitted to the Kansas bar in 1979. On November 8th, 2022, the ODA filed a formal disciplinary complaint against Mr. Ash. On November 22nd, Mr. Ash filed a timely answer, admitting to all the allegations contained in the formal complaint. Thereafter, the parties decided to forego the disciplinary hearing that was scheduled for January 11th, 2023, and instead enter into a summary submission agreement under Supreme Court Rule 223. The parties have stipulated that Mr. Ash violated KRPC 5.5A and Supreme Court Rule 231B by continuing to practice law after he was suspended, and violated KRPC 8.4C, engaging in conduct involving dishonesty, by continuing to hold himself out as a licensed attorney to his client and to opposing counsel after he was suspended. Because the parties have entered into a summary submission agreement, the only issue before this court is whether the court agrees with the parties' recommended sanction of an indefinite suspension with a retroactive start date of January 3rd, 2023, the date the parties entered into their summary submission agreement. I want to give a brief summary of the stipulated facts. In early April 2021, client KEB consulted with respondent about preparing a prenuptial agreement. On April 8th, respondent sent a draft of the agreement to KEB. Part of the agreement included certificates that respondent and the attorney that KEB's future spouse would sign, confirming that they had went over the agreement with their respective clients, and also as well reviewed the financial statements that the other spouse had provided. Accordingly, the certificates contemplated that respondent would be doing additional legal work for KEB prior to the premarital agreement being executed. Also occurring in April 2021 was the respondent had a disciplinary case that was pending before this court. Oral arguments for respondent's disciplinary case occurred on April 2nd. On May 7th, 2021, this court issued its opinion in respondent's disciplinary case, concluding that respondent had violated numerous rules of professional conduct, The court suspended respondent for 3 years, but allowed suspension to be stayed after 6 months if respondent entered into a probation plan approved by the ODA. In August of 2021, while respondent was suspended, KEB emailed respondent asking him whether he had heard from her fiance's attorney, Carolyn Sue Edwards. Instead of informing KEB at that time that he was suspended and could not assist her with finalizing the agreement, he informed her he had not heard from Ms. Edwards. Subsequently, in September of 2021, respondent began communicating with attorney Edwards regarding the prenuptial agreement. They made revisions to the agreement based on those communications, and he advised KEB regarding the changes made to the agreement. Late September 2021, attorney Edwards learned of respondent's suspension. She reported the suspension to her client and to KEB and filed a complaint with the ODA. Under this court's case law, specifically State Ex Rel. Stephan versus Williams, 246 Can 681, it's a 1990 case. Respondent's actions in September of 2021 constituted the practice of law and in turn violated 5.5A and Supreme Court Rule 231B. During the September 2021 time period, respondent held himself out as an attorney to both KEB and to attorney Edwards, and this constituted a violation of 8.4C. Based on the facts and rule violations, the parties are jointly recommending an indefinite suspension, again with a start date of January 3rd, 2023. The ODA believes that the recommended sanction is appropriate given the seriousness of the current conduct and respondent's prior disciplinary history. But the sanction also takes into account the respondent's willingness through the summary submission process to admit to his misconduct and accept responsibility. In conclusion, the ODA would ask this court to accept the parties' summary submission agreement, impose an indefinite suspension in order that suspension begin to run January 3rd of 2023. Unless the members of the court have any questions for me, I'd waive the remainder of my time and address the court again during the rebuttal.
Excuse me, I was curious about why you wanted to start the definite suspension period on the date of signing. I realize we're only talking about a couple of months. I'm not terribly animated about it. I'm odd, at least to me, when I was reading it, so.
It was an offer that I had made to urge Mr. Esh to enter into the summary submission agreement. It also, I think, with the start date of January 3rd is recognizing that he, cooperated with the process, entered into the summary submission agreement. So that was why we're asking for the retroactive start date. Thank you.
Your Honor, if it please the court, Mr. Ash does not disagree with having his license terminated. Practice accounting and has no practice law in the future. Complete agreement with having his license terminated.
Further from the respondent?
Unless the court has any questions, I would waive rebuttal.
Thank you to all of you. Today, we'll take this matter under advisement. I'll now call 125-968 in the matter of Christopher Barnes. Mr. Vogelberg.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Madam Chief Justice, I would request 2 minutes for rebuttal. Thank you. This is original action and attorney discipline involving the respondent Christopher C. Barnes. Mr. Barnes was admitted to the Kansas bar in September of 2012. This matter involves three separate disciplinary complaints. The first complaint, DA 13349, concerns Mr. Barnes's conduct towards attorney Toby Bittner, who was appointed as a guardian ad litem for two minor children in a Johnson County domestic case where Mr. Barnes was representing the father. During the course of that case, Mr. Barnes repeatedly accused Ms. Bittner of unethical conduct by failing to fulfill her duties as a GAL and being improperly biased against his client. In a July 18th, 2019 journal entry, the district court sanctioned Mr. Barnes for his conduct towards Ms. Bittner, concluding that his conduct was done in bad faith. Furthermore, the court found that Mr. Barnes violated a prior court order directing him to receive the court's permission before filing a motion accusing one of the attorneys in the action of unethical conduct. Second complaint, DA 13565, concerns respondent's actions in representing a respondent in a protection from abuse case in Johnson County District Court. While that PFA case was pending, Mr. Barnes sent emails to opposing counsel Joseph Booth suggesting that unless Booth's client dismissed the PFA petition, Mr. Barnes's client would pursue unrelated criminal charges against the client and report the client to the IRS for tax fraud. The third complaint, DA 13665, concerns respondent's conduct towards attorney Kelly Cooper. Mr. Barnes and Ms. Cooper were representing opposing parties in a post-divorce child custody dispute in Johnson County District Court. Mr. Barnes, on behalf of his client, filed a motion to amend the party's parenting plan. While that motion was pending, Mr. Barnes sent an email to Ms. Cooper informing her that unless her client agreed to the proposed changes to the parenting plan, his client would pursue criminal charges against Ms. Cooper and would file a disciplinary complaint against her. Three complaints proceeded to a formal hearing that occurred on December 1st of 2022. Prior to the hearing, the parties entered into a limited stipulation of facts and a stipulation regarding the admission of exhibits. After conducting a one-day hearing, the panel took the matter under advisement and then issued its report on December 27th of 2022. In its report, a majority of the panel concluded that Mr. Barnes's conduct in the case involving GAL Toby Bittner violated 3.4C, knowingly disobeying an obligation under the rules of a tribunal. In the PFA case involving attorney Joseph Booth's client, a majority of the panel concluded that Mr. Barnes' conduct violated 4.4A, using means that have no substantial purpose other than to embarrass, delay, or burden a third person. 8.4A, violating the rules of professional conduct through the acts of another. And 8.4D, engaging in conduct prejudicial to the administration of justice. Regarding respondent's conduct toward attorney Kelly Cooper in the third complaint, the majority concluded that respondent's conduct violated rule 4.4A, 8.4A, and 8.4D. Finally, the majority found that in all three complaints, the respondent repeatedly conveyed improper threats for the purpose of gaining an advantage for his clients. Accordingly, based on this pattern of misconduct, the majority concluded that respondent violated 8.4G, engaging in conduct that adversely reflects on his fitness to practice law. Regarding the sanction, at the disciplinary hearing, the ODA recommended a 6-month suspension. The respondent asked to be placed on probation for 1 year, consistent with the terms of his proposed probation plan. A majority of the panel recommended an underlying suspension of 3 months and placing a respondent on probation for 2 years pursuant to the terms of his probation plan. One member of the panel filed a concurring and dissenting opinion. He concurred with the majority's conclusions regarding rule violations in DA 13349, the complaint involving Toby Bittner, and in DA 13665, the complaint involving Kelly Cooper, but dissented from the majority's conclusion regarding rule violations in DA 13563, the complaint involving Joseph Booth. Panel member concluded that in DA 13563, the ODA had failed to sustain its burden of proof by clear and convincing evidence that the respondent had committed rule violations. And because the panel member believed that the ODA did not prove rule violations in DA 13563, not agree that the respondent engaged in a course of conduct throughout the three complaints that would support an 8.4G violation. Regarding sanction, that panel member believed that a public censure was warranted given that the respondent had not been disciplined prior to engaging in the conduct, resulting in the current complaints that have been filed against him. The ODA docketed this matter with the appellate clerk's office on January 20th, 2023. After initially filing exceptions to the final hearing report on February 9th, 2023, the respondent withdrew his exceptions on March 10th. Accordingly, the panel's findings of fact are deemed admitted, and the only issue that's now before the court is what sanction to impose upon the respondent. As mentioned before, the hearing panel, a majority of the hearing panel recommended an underlying suspension of 3 months and placing the respondent on probation for 2 years according to the terms of his proposed probation plan. At this time, the ODA would recommend to this court that it adopt the majority's recommendation. The ODA believes that Mr. Barnes's conduct since this hearing shows that the panel's recommended sanction is a sufficient deterrent to protect the public and the legal community. Mr. Barnes ultimately decided not to file exceptions to the hearing panel report, which indicates to the ODA that he acknowledges that his actions were wrong and that he accepts responsibility for his conduct. Mr. Barnes, since the hearing, has reached out to me on several occasions through email and through phone calls, making sure that he was complying with the terms of his probation plan as far as the reporting requirements to the ODA. My interactions with Mr. Barnes has been very cordial, and it appears to me that he is very serious about complying with the terms of his probation plan.
Remind me what happens at the end of the have to make a decision that successful compliance with you as the ODA.
As a requirement,
And issue a letter or something, doesn't come back to us under that circuit. Unless we say so.
I
Right?
believe under Rule 227, the respondent has to make an application to this court to say that I've fulfilled the terms of my probation plan. I am now ready to be released from probation. And then I think that provides us to provide a response to that. Regarding Mr. Barnes' probation plan, it requires Mr. Barnes to enter into a monitoring agreement with KLAP. Mr. Barnes signed a waiver allowing the ODA to contact KLAP to get information about the monitoring agreement and to confirm that he's in compliance with it. I reached out to KLAP prior to today's argument. They confirmed that he is currently in compliance with his monitoring agreement. Johnson County Attorney Jason McClaskey, who practices family law in Johnson County, has agreed to be Mr. Barnes's monitoring attorney under the KLAP agreement. They have been meeting every month to discuss issues that arise in Mr. Barnes's practice. Mr. McClaskey, in addition to acting as a monitoring attorney, has kind of taken on the role of a mentor for Mr. Barnes and exchanging emails with Mr. McClaskey. He has indicated that he believes that Mr. Barnes has learned from his mistakes and will strive to establish a better working relationship with opposing counsel, and that he is sincerely trying to rehabilitate his reputation amongst the attorneys who practice family law in the Johnson County District Courts. Furthermore, Mr. Barnes's probation plan requires him to attend 2 monthly coaching sessions with Professor Mike Hoflick of KU Law School to discuss the rules of professional conduct. Professor Hoflick has reported to me that Mr. Barnes has diligently attended these sessions and that he is an active participant during the sessions. Professor Hoflick indicated to me that his interactions with Mr. Barnes has shown him that Mr. Barnes has committed to fulfilling the terms of his probation plan. In conclusion, I would ask this court to affirm the conclusions of the hearing panel regarding rule violations. I would ask the court to adopt the majority's recommendation of an underlying 3-month suspension and place the respondent on probation for 2 years according to the terms of his probation plan.
I have one question. In the materials, as I was reviewing them, it appears that Mr. Barnes owns and manages his own firm, and that there are many attorneys within the firm that work for him, basically, right? Do you know how many attorneys that is?
I believe there's approximately 4.
4. And do you know whether in making the recommendation, whether the disciplinary panel or the disciplinary administrator's office took that into account as part of his probation plan?
That is addressed in the probation plan, where Mr. Barnes acknowledges that if an issue arises in one of his cases, that he will take it to the other associates in his firm to discuss that issue before proceeding forward. And so I think there is acknowledgement of, I guess, doing more consultation with the other attorneys in his firm before any actions are taken. But as
The 100% partner, and they are associates, right?
that's my understanding.
I had a quick question about, just to help me understand or make sure I'm understanding the reasoning of the dissenting opinion correctly, and I'm focused on paragraph 142, where the dissenting panel member, as I read it at least, says that part of the rationale for public censure is that there was no prior discipline. It kind of suggests to me that the dissenting member thought that the panel majority viewed the case as if there had been prior discipline or prior violations. But as I read the panel majority, that's not the case.
No, that's certainly,
I mean, the panel majority said there had been no prior discipline.
yeah.
What, can you shed any additional light on what was the actual disagreement then?
I
And
think.
I mean, if you know, maybe. you don't.
Right. I think the dissenting member was concerned that the first complaint, that the journal entry and the subsequent complaint from Judge Winnell and Kate Zichtema, who represented Toby Bittner, those complaints came in end of July of 2019. And of course, we're looking at a hearing that takes place December 1st of 2022. And so I think the dissenting member was concerned about the length of time that it took to come to the hearing. My response, if I knew that that was a concern of his, would have been, yes, that's true, but then we had a subsequent complaint that came in at about the same time that the investigation of the first complaint was completing, and thus that was placed on hold until the investigation of the second complaint was concluded, and then we had a third complaint that was filed in our office, I believe, March of 2021, and so that kind of explains a little bit of the slowness.
Just trying to understand in good faith what the dissenting member was saying. Is the concern that you're piling on essentially? I mean, I realize I'm asking you to.
I think
I'm not suggesting your office was piling on. I'm just trying to understand what the.
I think the reasoning is he felt that since Mr. Barnes had no prior discipline, that
Basically, it
public
wasn't,
censure would have been
yeah,
appropriate. in this
and
case.
basically it wasn't fair to use three different cases to. And I'm not even suggesting I necessarily agree with that. I'm just trying to understand what was the.
I think that was the reasoning.
Okay, thank you.
Unless the members of the court have any additional questions, I would waive the 13 seconds I have left.
Thank you, Mr. Wigglesworth.
Thank you.
Barnes?
If it may please the court, Respondent Christopher Barnes, again appearing pro se on behalf of myself. As the court's well aware, I am the respondent in this action. And I very first and foremost wish to thank this court for its time, because I realize the importance of this proceeding in the judicial process and managing the state bar. Although I wish I was here under different circumstances, I'm nonetheless thankful for your time. I also wish to notoriously, first and foremost, after that, issue an open apology on the record, understanding this is a public proceeding. I wish to apologize to this court for my prior actions. I wish to apologize to the bar of the state of Kansas. I wish to apologize to the ODA and Mr. Vogelsberg. I wish to apologize to the attorneys who were involved in any of the proceedings, as well as to Judge Winnell specifically, who had found order violation due to a motion fine that was submitted without checking with him first. With that being said, I next wish to make sure this court understands that I am beyond remorseful and contrite regarding my prior actions. There is no excuse for what I did, and that is why, upon filing the exceptions and further reflecting, I decided to withdraw those exceptions.
Let me interrupt.
Yes, sir.
About sounding too school-marmy about all.
Sure.
Based upon your counseling sessions and your interactions, other members of the bar, what's your takeaway in terms of the source of why did you do this? How do you react? Why did you react the way you did?
Yes, sir, I can answer that question. I think that's a combination of a multitude of factors. I think one of the chief and foremost would be at the time of initially committing the first violation with the Reed matter. And even subsequently following that, my inexperience. I practiced for approximately 5 years before going on my own. And I will take some time to try to answer some of the inquiries of the other justices. So I think inexperience was a big role to play. I also, oddly enough, just on the 13th of April of last month, Mr. Nick Badgerow presented a CLE to the Johnson County Inns of Court on the pillars of professionalism. It was aptly timed, needless to say, and I took a lot away from that, including an even firmer realization that one thing I did not do well initially, but I've taken strides to become much more mindful of, is managing client expectations and client control. Again, as an inexperienced attorney at the time, I did not realize the true fundamental importance of making sure from the very first moment you begin client that you begin to set realistic expectations. And as Mr. Badgerow put it best, I believe, is not taking on the client baggage. And I think because of my nature of who I am, which in the 15 minutes, I unfortunately cannot give you a background into all of that, but I'm a caring and compassionate person. And I think at times, not in the best manner, I took my client's baggage on as my own. And I didn't initially make sure that they understood what was right and wrong and what things we can do and can't do. Since that time, though, I wish to make sure this court's aware I've taken tremendous steps in trying to rectify that. And I wish to be very forthright with this court, as I believe you deserve nothing but my utmost candor. Some may think I'm a little crazy for saying this, but I am thankful for this whole experience and this whole process. In a manner that I'm a firm believer that sometimes things in life might happen. Although at the time they might seem like a bad situation, you can be removed from that and later on look back and see something differently. And while I would certainly never repeat my actions, I am extremely thankful and grateful for what I've learned through the process. It's not the best way to learn. There's better ways to learn. I wish learning didn't bring me before you today. But nevertheless, I'm here. And I want this court to know that why I say I'm thankful for the process, because, for example, meeting Professor Hoflich has been a huge blessing to me. We formed a good professional relationship, and same with Mr. McClaskey, although I knew him somewhat before due to our time in the Inns of Court together, and he had served, and I had spoken to him a few times prior to this all taking off, if you will. I have formed a great mentorship, as Mr. Vogelsberg put it, because although he is my monitoring attorney, he is also serving in a mentorship role, which I'm thankful for. And it is things like that that I realized that would have never inured and come about. And I truly believe that this was a way of somebody somewhere intervening and making this happen now. So hopefully, and I can assure the court it will, allow me to learn a lesson so I don't repeat any such mistakes in the future, or even more so make worse mistakes. So for that, I am, again, thankful for the process. I would not wish to be here again. And if I could do it again, I would do it differently. I am nevertheless thankful for the process. And I would want this court to know and be reassured that I am going to continue to take whatever steps are necessary, and I can get into some of those in detail, to ensure this type of conduct never happens again. And I can assure the court that irrespective of its decision today, even if public censure should be the decision, I still continue to plan to meet with Mr. McClaskey every month and have him serve as a monitor and a mentor. And I assure this court of that. I've also spoken with Professor Hoflich, and he and I have also discussed that irrespective of this panel's decision, the court's decision today, I still plan to continue to meet with him at least once or twice a month. We've even talked about potentially co-authoring an article together in the future for the KU Law Journal. And again, it's these things that would have never came about. Indeed, I probably would never had cause to meet Professor Hoflich other than this unfortunate series of events. And so for those things, I am again thankful. And it's because of those people I've met in these subsequent interactions, including with the ODA's office, that I have again understood the profound nature of what I did and the incorrectness of it all. And aptly, I feel like when Mr. Badgerow gave his CLE last month, a lot of it was on the pillars of professionalism. And I realized pillar 2 is the duties of professional out of this court and all courts. And pillar 3 is the duties I owe to other professionals in the community. And I understand that although those are not codified, and there are not sanctions for violating those, that as Mr. Badgerow said, we should always every day come into our practices with the appropriate attitude and actions. As he indicated, to have an attitude of professionalism at all times and to act professionally at all times. And I realized there had been times in the past when I hadn't done that. And if I am answering your Honor's question in a roundabout way, unfortunately, prior to me going out on my own, although I did work for Format, I didn't have much mentorship or guidance there, which is something I didn't realize till afterwards. I was kind of put into the fire. Obviously, I think that allows an attorney to train well, but I lacked some guidance that likely could have been extremely helpful. Since going out on my own, if it would please the court, I have started my own practice. I started in a small 8x10 room by myself with really ugly yellow walls. I now am in a larger office. I presently do manage 5 associate attorneys, and we are getting ready to extend an offer to a 6th. I also employ 2 full-time paralegals, as well as an office coordinator. And Sean, but we gave him that title because we feel he deserves it. And there's also an office manager. And one of the many things I've done as a means of implementing steps to avoid things happening like they did before was utilizing all those resources. I have policies in place where, again, every initial email, although it comes to me, I'm not responding to every last email. I have paralegals who help do things like that for me now, where I can have time and give focus to things that I really need to. I've also learned the importance of, again, not to try to steal much from Mr. Badgerow, but I think, I don't know if he termed the phrase or someone else did, but he called it keyboard catharsis or something of that nature, keyboard courage. And I realized that there's a lot to be said about reading an email. And even if I decide to type a timely response, to let it sit there, because I can take 24 hours to respond. That's something I didn't do before. And I realized that maybe a small thing to say, but the power in doing so I have found to be tremendous, because I can tell this court that even over the last 2 years, there's been at least a handful of emails that I've typed out, let sit, and then the next morning just hit delete, because I realized that that wasn't constructive to the process and the problems I'm trying to solve. So if that's responsive to the court's question, I again just want this court to know that moving forward, I take my past actions seriously. And there's no excuses for them. I have a lot of work ahead of me, as Mr. Vogelsberg indicated and Mr. McClaskey's reported. I'm in the process of meticulously trying to repair my reputation with other professionals who I realize, again, I owe professional duty to. And that's going to take some time, as everybody's sure I'm aware. And I realize that moving forward, my actions have to be consistent in a manner so people do believe, I hope this court will find, that he learned something from that process. I will say there are parts of me that wish, after the first incident and when I had applied for diversion, that could have been something that came about. Unfortunately, there was this thing that popped up in all of our lives called COVID-19, and that put a delay. And I realize that's not within the peer review or anybody's fault because of the timing. And there were subsequent actions taken. I do believe to be somewhat responsive to your Honor's prior question. That was part of the reason I believe the dissent, at least with respect to the middle decision, didn't agree, and furthermore was recommending the public censure, because as the record shows, Rowe, who was the local investigator, who I'm also thankful for meeting, had recommended diversion, I believe for all three or two of the three. And I understand that's not something we can do today. That's why I want, again, this court to understand that regardless of what happens, I'm going to change my actions moving forward. I've already taken steps to, and I don't plan to go back. I was listening to a sermon the other day and it was aptly titled "Forward, Not Finished." And that's kind of my theme for today is I'm going to try to move forward from where I'm at, learn from everything that's happened. And again, part of me feels thankful because I feel like this was an intervention at some site to ensure that I'm bound for greater things, that I don't make thoughtless mistakes in the future. And some of them were thoughtless, I would admit. Emotional. Some of them were emotional responses that I shouldn't have. Again, had I taken the time and had I maybe had some mentors at the time to speak to or other attorneys to talk to, I may have thought twice about my actions, and I certainly have now. So if it may please the court, I will open myself up for questions, realizing I only have 2 minutes left.
I have a question. I have a little bit of a lead up to it. I practiced law for 19 years before I went on the bench, and I remember an email I received accusing me, another attorney accused me of lying. As a result, I went through every correspondence I'd ever had with that attorney because I thought, how in the world could he have thought that I had done that? I prided myself on being truthful. And going through all of that, I didn't find anything that I thought he could fairly say would have been interpreted by him as a lie. And, nothing ever came of it. But clearly, that would have been unethical for me to lie to him. And you didn't mention anything about empathy for the people who received the missives that you sent. But I know personally, I will never forget that heart-stopping moment and what I did in response. So I would like for you to address that, if you will, what your considerations are for the empathy of other counsel who receive your correspondence.
Yes, ma'am. I have, to answer that question with respect to all three of the counsel involved in the three different matters, I have opened and issued apologies. Indeed, I have offered to sit down in a sense to break bread to start to repair that relationship. And I have indicated to all of them an apology, tried to find ways to, I realize with those professionals in particular, I have a longer road ahead and a harder job to do to repair that relationship. And I am mindful of the court's question, and I made some poor decisions, and I realized that in hindsight, making those phone threats or emails being sent was far from professional. It wasn't appropriate, and that is why I have sought to be apologetic to them as well, and have asked when they are ready to provide that forgiveness. But I understand that's a personal decision for each of them, and I can't force that. I can be candid with this court, although I have offered to sit down. So far, no one's taken me up on that. But one thing Mr. McClaskey and I, for example, have been discussing is a way that he might step in to try to help do that, thinking that it may be more comfortable, because I can give one clear example. Mr. McClaskey has a pretty close professional relationship with Mr. Booth. So we've already been discussing trying to find a time where the three of us can sit down together and again, talk through what happened, at which time am I sure the court, I will of course issue apologies again to Mr. Booth and reassure him, as I am this court, that you won't see that again from me ever. And I concluded the case with him not long ago, and I thanked him at the time. I told him I realized this has not been the most pleasant case between the two of us, but that I hope that this one case wouldn't define our professional relationship, and that I look forward to working with him in the future should that opportunity arise. I don't know if that's fully responsive, but I guess that would be my answer, Your Honor.
Thank you.
Welcome. Other questions from the court? Thank you again for your time, Your Honors.
Members have any questions for me, I would waive my rebuttal.
Very technical question. The recommendation, I believe, is for the 2 years to start running as of the date of the final hearing report.
That is correct.
Go ahead.
I will slightly amend my initial recommendation. I would recommend that the term of probation start upon this court issuing its opinion. If the court ultimately chooses to put Mr. Barnes on probation, I would ask that the probation term start to run on the same date as the opinion being issued.
I think I'm confused. What, I thought the recommendation was 3 months suspension and 2 years of probation, but you're just recommending the probation part?
No,
Oh, it's,
excuse, I apologize.
no, now I understand.
Underlying 3-month term,
Okay.
the probation term of 2 years, I'm recommending that it start upon the court issuing its opinion. In the final hearing report, the majority recommended that it start upon the date of the hearing report, issued December 27th of 2022.
And so the 3 months suspension is suspended.
Correct.
The recommendation of both the hearing panel and you, and then there's just a disagreement on whether it is retroactive to.
That's correct.
Would be about a 5-6 month difference roughly. Well,
No, go ahead.
at least the final hearing report was December 22. Correct, yeah.
Yes. Thank,
No, I thought you were gonna have 1 second left to give us back. We didn't even quite make that. Anyway, well, thank you. Thank you to both counsel for your comments and arguments today. We will take this matter under advisement. Court is now adjourned.
All right.